Hello everyone, welcome to Administrative Law Lectures. This video is in continuation of the Administrative Law video in the part 1. Here, we'll cover the causes and the reasons for the growth of administrative law, definitions of administrative law, and the scope of administrative law. Causes and the reasons for growth of administrative law. They are the adoption of the concept of a welfare state. As the states changed their nature from laissez-faire to that of a welfare state, government activities increased, and thus the need to regulate the same. Thus, this branch of law developed. The inadequacy of legislature. The legislature has no time to legislate upon the day-to-day ever-changing needs of the society. Even if it does, the lengthy and time-taking legislating procedure would render the rules so legislated of no use, as the needs would have changed by the time the rule is implemented. Thus, the executive is given the power to legislate and use its discretionary powers. Consequently, when powers are given, there arises a need to regulate the same. The inefficiency of judiciary. The judicial procedure of adjudicating matters is very slow, costly, complex, and formal. Furthermore, there are so many cases already lined up that speedy disposal of suits is not possible, even for very important matters. Hence, the need for tribunals arose. Technicalities. The important problems could not be solved by mere literally interpreting the provisions of some statutes, but required consideration of various other factors and the technical knowledge of the subject matter. It could not be done by the ordinary courts of law. Therefore, industrial tribunals and the labor courts were established, which possessed the techniques and the expertise to handle these complex problems. Scope for the experiment. As administrative law is not a codified law, there is a scope of modifying it as per the requirement of the state machinery. Hence, it is more flexible. The rigid and legislating procedures need not be followed again and again. Definitions of administrative law. Ivor Jennings has defined administrative law as the law relating to the administration. It determines the organization, powers, and duties of the administrative authorities. This is the most widely accepted definition of administrative law. According to Wade, administrative law is the law relating to the control of governmental power. According to him, the primary object of administrative law is to keep powers of the government within their legal bounds so as to protect the citizens against their abuse. According to Casey Davis, administrative law is the law concerning the powers and procedures of administrative agencies, including specially the law governing judicial review of administrative action. Garner also adopts the approach advocated by Casey Davis. These are some definitions of administrative law given by different jurists. Scope of administrative law. Administrative law is the branch of public law, which means that it deals with the relationship of individuals with the government. The boundaries of administrative law extends only when administrative agencies and public officials exercise statutory or public powers, or when performing public duties or public functions, not when performing private functions. For example, if a citizen works in a state-owned factory and is dismissed, he or she would sue as a private law function. However, if he or she is a civil servant, he or she would sue as a public law function. Similarly, if residents of the surrounding community were concerned about a decision to enlarge the state-owned factory because of the environmental pollution, the legality of the decision could be reviewed by the courts as a public law function. The point here is that the rules and the principles of administrative law are applicable in a relationship between citizens and the state. They do not extend to cases where the nature of the relationship is characterized by a private law functions. Procedures. Many of the definitions of the approaches to administrative law are limited to procedural aspects of the subject. It is primarily concerned with the official actions and the procedures and puts in place a control mechanism by which administrative agencies stay within bounds. Hence, to a wider extent, the study of administrative law has been limited to analyzing the manner in which matters move through an agency rather than the wisdom of the matters themselves. With respect to judicial review, the basic question asked is not whether a particular decision is right or whether the judge or the minister or officials have come to a different decision. The questions are what is the legal limit of power or a reasonable limit of discretion the law has conferred on the official, whether the power has been exceeded or otherwise unlawfully exercised. Therefore, administrative law is not concerned with the merits of the decision, but with the decision making process. Conclusion. Administrative law is the law governing the executive to regulate its functioning and to protect the common citizenry from any abuse of powers exercised by the executive or any of its instrumentalities. It is a new branch of law which has evolved with time and shall continue to evolve as per the changing needs of the society. The aim of administrative law is not to take away the discretionary powers of the executive, but to bring them in consonance with the rule of law. The primary function of administrative law is to keep governmental powers within the limits of law and to protect the private rights and the individual interests. Thank you for watching this video on administrative law.